in 1996, establishing the concept of unlawful presence, which makes it harder for people who were in the United States unlawfully to then get green cards once they left the United States. And we're going to be talking about what unlawful presence is, and going into details about the bars, and then a little bit about how to get a waiver. Unlawful presence does not necessarily mean the same thing as being illegal in the United States, and it's very important to understand that. You can be unlawfully present in one of three ways. Either you entered the United States with a visa and then you overstayed, or you entered without inspection, which means you snuck across the border. You were not waved through, you were just snuck across the U.S. border from Canada or Mexico or some other place. Or you're a status violator. Status violators can be a little more tricky because what does it mean to violate your status? Well, let me just give you a simple example. You come to the United States, you're a visitor or you're a student, and then you have a job illegally working for cash under the table. You're clearly a status violator. So there's three types of unlawful presence bars. The first one is the 3-year bar. The 3-year bar applies to people only if they're over 18 years of age. They have had unlawful presence for 180 days or more, but less than a year, and then they left the United States. Those people are barred for 3 years from getting a green card unless they can get a waiver, which we call an I-601 waiver. The second type of bar is the 10-year bar. And these are people who stayed unlawfully present in the U.S., again, after their 18th birthday, for 1 year or more, and then left the United States. And again, they're barred from returning for 10 years unless they get a waiver. And then finally, another bar, which actually in immigration law deviates a little from the other two bars, because it doesn't explicitly say you have to be over 18 years of age, and this is being litigated right now. But if you were deported from the U.S., or you had over a year of unlawful presence, you left the U.S., and then you came back without inspection, then you cannot get a waiver at all until you've stayed outside the United States for at least 10 years. Now, a lot of people think unlawful presence is kind of simple. Let me just tell you a few interesting facts that probably will change your mind. We've had cases, I had a couple come to me and they had won the visa lottery, but they had actually stayed in the U.S. over 180 days unlawfully, and I knew if they exited the United States, they would not be able to come back for 3 years, and the visa lottery is only good for 1 year, so they would have been out of luck. What I did is I made sure that they got put into a deportation hearing in front of an immigration judge. He gave them voluntary departure, and that is an exception to the 3-year bar. So with their lottery winning, they were able to get interviewed for a green card and a few months later come back and be permanent residents of the U.S. Another interesting fact concerns status violators. When does their unlawful presence start? Let's say that I've been working illegally on my student visa for the last 3 years, and a month ago the Immigration Service caught me, and they put me under deportation proceedings. Do I have 3 years of unlawful presence? The Immigration Service says no. I only have from the time I was caught until the time I leave the U.S. So as long as I leave the U.S. within 180 days, there's no unlawful presence bar against me. The third fact that I think is very interesting, and we actually had a case that we won in Chicago last year that concerned this, is somebody who has unlawful presence and they have not, well, they left the United States on an advanced parole, and then they have been in the U.S. for over 3 years and they're subject to the 3-year bar. Does the 3-year bar mean they have to have the unlawful presence satisfied by going outside the United States for 3 years? Again, there's an interpretation by the General Counsel of the Immigration Service that says the 3-year or the 10-year bar can be accumulated within the U.S. as long as you come back legally on an advance parole. And how about an exit on the advance parole? There's a recent case by the Board of Immigration Appeals where somebody had unlawful presence in the United States and they left and came back, but it was on the advance parole. They said leaving the U.S. on an advance parole does not trigger either the 3-year or the 10-year bars. We are going to have another video about waivers because that's a fairly complicated subject, but I just wanted to end this video by giving you the very basics of what you have to do to get a waiver. Number one, you have to be able to prove extreme hardship to a qualifying relative. Who qualifies? Well, it can either be your spouse or it can be your parents, as long as they're either citizens or permanent residents of the United States. Hardship to you does not count at all. In fact, hardship to your kids, even if they're U.S. citizens, does not count. Let's say that you're the non-working spouse and your other spouse is bringing home the paycheck. If you leave the United States, who's going to take care of the kids for 3 years or 10 years? So you should be able to use taking care of the kids as a factor in showing that your spouse would experience extreme hardship. But it's not extreme hardship to the kids, but extreme hardship to the spouse. And there's many, many more things that I can bring up about proving extreme hardship, but that will wait till our next video.